UACI as a power connector. We are hosting this session as part of the SBIR, STTR America's Seed Fund, and working closely with DOE, the CETO office, the Water Technology Office, in hosting these sessions. So we just wanted to give you a quick reminder that if you have any questions specific to those departments, you're able to reach out to these email addresses, water.sbir or solar.sbir, if you have any questions that we weren't able to answer or that you want a public response. We are one of 20 connectors in the US, power connectors working with DOE on different funding opportunities. We're so honored and thankful that we have the opportunity to work with great people and teams and companies like yours, and hope that we can help support you during this time. But if there's other funding opportunities that come up, please let us know, and we'd be happy to connect you to someone else that might be working on that opportunity. So just let us know and keep us posted. For this particular effort for SBIR and STTR for the DOE program, there are other power connectors that are supporting this effort as well and have some other events. And I just wanted to give you a reminder of that. The Clean Energy Business Network, ADL, Arrowhead Center, and EFN Entrepreneur Futures Network are all offering different levels of support and information. So if you'd like to see what other events they have coming up, you can click on this link here and it'll take you to all the events that all 5 power connectors are offering. For UACI, we have, after today's session, we will be launching a commercialization workshop. As you prepare your commercialization strategy, we have broken it into 4 sessions that we'll be working on and giving you kind of an overview of these areas as you're thinking of your commercialization strategies. And we hope that you'll sign up. You can do that through this link here, and they'll be every Friday starting next week for 4 weeks. And those will also be recorded and put on our YouTube channel. But we hope that you'll be able to join us. For today's session, we have an honored guest with us, David Metzger, who is an intellectual property attorney who comes to us with a wonderful background and a ton of knowledge and support and resource. So we're very thankful that he was able to join us today. This is a long list of his accomplishments and honors and those that he's achieved during his career. But just a quick touch on him: he was the former administrative assistant to a U.S. representative, staff director and chief counsel to a small business committee subcommittee, and assisted in drafting early versions of the SBIR Act. A lot of that still remains, or many of that still remains intact, and so we're really thankful to have him here today. He's taken some time out of his schedule to be here today. So David, I'll turn it over to you, and welcome.
Okay, well, thank you for the kind words, Amanda. And notwithstanding the title of this, which is a little bit intimidating, it says laws. We're not going to talk legalese. We're going to talk business. So those of you that saw the word laws and decided you might hang up, don't. We're going to talk business and just some regulations behind the SBIR Act. So with that, let's buckle our seatbelts and put our tray tables in the upright and lock position and get started. There are 3 basic laws that provide us with the regulations that we're going to talk about. One is the SBIR Act, which was initially enacted by Congress in 1982. It was amended and recently reauthorized on September 30th, 2022, last year. That was the date it was scheduled to lapse. So Congress was not very quick in doing it. That's why most of us wish they would permanently reauthorize the SBIR Act, but they haven't done it. The second major document that we're going to talk about the most are the laws that implement that act. And they are contained in the SBA, SBIR, STTR policy directive. Now, don't let that word policy fool you. That policy directive has the force of law, as we're going to discuss a little later. There is a third body of law, it's very brief, and that is in 13 Code of Federal Regulations, Chapter 121. And that's the SBA regulations in the Code of Federal Regulations. at 121.701 through 705, they really discuss, SBA discusses size regulations. They have not incorporated the policy directive into their Code of Federal Regulations, but you can find that whole policy directive on the SBA website. And I strongly urge you to run it off and keep it handy. Now, you don't have to sleep with it under your pillow like I do, but your staff and you should keep it handy. Slide. SBA issued this policy directive pursuant to notice and comment rulemaking in 1992. And ever after that, it became law. Now, that notice and comment rulemaking is the process that also promulgated the laws under which you pay taxes. And I think we all can agree, yeah, that those tax laws are binding and real. Well, so is the policy directive. It's law, and that's important to remember. It was dramatically changed by a final rule in the Federal Register on April 2nd, 2019. And that final rule said that that new rule and new set of changes would be effective on May 2nd, 2019. And that was a dramatic change, a big amendment. There were some subsequent amendments that occurred after 2019, but those did not affect anything we're going to talk about today about SBIR, STTR data rights. Just as a little bit of background, those subsequent legal changes were made by SBA in response to one of the most horrible government accountability office decisions that I have ever seen. They mangled the definition in that ASRC decision of what a phase 3 is, and SBA clarified that an acquirer, either through acquisition of the SBIR firm or acquiring an expired contract or acquiring a pending contract through the novation process in FAR Part 51, could obtain phase 3 rights. So that's the way Lockheed, even though it's a very large firm or Raytheon or whatever, can actually acquire phase 3 rights because they would own prior SBIR effort. And that's included in the definition of phase 3. Those are recent amendments. They were in response to this awful GAO decision. I wrote an article on that decision and said that GAO decided that decision, quote, in a drunken stupor. Next slide. Let's talk about what that policy directive actually does. It applies to both SBIR and STTR now, and to civilian and military funding. So there's not two sets of laws anymore applying one or the other. Now, for convenience, I'm just going to refer to SBIR, but because of that directive common to both programs, everything I say is going to apply equally to SBIR and STTR. That common directive actually is one little section that describes the unique aspects of STTR, which require, unlike SBIR, a nonprofit partner. By way of background, the universities hated SBIR because they claimed it was a nick out of R&D funding by the agencies, and the universities considered that their money. Well, STTR finally was passed because the universities realized if you can't fight them, join them. And so now they get their share of SBIR funds through STTR with that mandatory nonprofit provision. That new directive announced a new SBIR data rights clause. And that clause is located, if you want to find it, in Appendix 1 of the new policy directive that I mentioned. Now, that new SBIR data rights clause and new directive constituted a dramatic change. It did away with the FAR SBIR clause, the Federal Acquisition Regulation clause, the DFARS clause for the defense agencies, and all other SBIR clauses. That SBA clause is now the only one to be used. All of the civilian agencies, including DOE, which funds this Power Connector program, immediately said they would use the SBIR clause. DOD, being DOD, was very slow to adopt it. They wanted to cling to their DFARS clause, but they have since announced in an interim rule issued by the Secretary's office that they will also use the SBIR clause. If you see that an agency included the FAR clause or the DFARS clause in your most recent SBIR contract, challenge them. They are to use, and they said they would use, the new clause, which we're about to talk about. This unified clause applies to all agencies, civilian, military, and it applies to both SBIR and STTR funding agreements. It changed the SBIR STTR protection period to a fixed 20-year protection period from the date of award. So you start on the date of award and you go 20 years out, and that's the birthday of the end of your protection period. The agencies were very confused by what was called the rollover provision, which could roll over all of the data rights protections to prior SBIR contracts to either 5 years out or 4 years out, depending on what was military or civilian, from the end of the contract. Well, that allowed SBIR protection of former contracts to continue in perpetuity if you kept getting SBIR contracts. So it did away with that. It applies to every contract now, every SBIR contract, task order, amendment issued on or after May 2nd, 2019. And as I said, that rollover provision now does not exist. And in its place is the 20-year protection period. Now, that sounds like SBA gave up something, but in my opinion, if you can't commercialize a product or invention or innovation within 20 years, you're probably in the wrong business. You ought to go bag groceries at the local grocery store. So 20 years is a long time, and it gives you a lot of protection. After that 20-year period is over, most likely the agency people that issued that funding agreement, they're no longer going to be around. Now, the agencies, all 11 SBIR agencies, have to incorporate that new SBIR clause by reference. And so do agencies that issue phase 3s, even if they're not a participating SBIR agency. The agencies can no longer check a box in their list of FAR clauses or DFAR clauses. They have to include that SBIR clause by reference. And the way they do it is they just say the SBIR, STTR clause referenced in Appendix 1 of the Policy Directive of 2019, effective May 2nd, 2019, is hereby incorporated by reference. They would do something like that. And that will occur probably in the special provisions section of the contract. Okay, let's go to the next slide. I'm often asked, and I think probably the Innovation Center might get asked occasionally, what exactly is SBIR data? SBIR data can be thought of in terms of 3 legal requirements. One is it's technical information. So if you're working under a funding agreement and you issue a report to the DOD or DOE or any agency, the name of your company, its address, your information about you, your birthday, those are all non-technical things. But the technical aspects of your invention are SBIR data. It has to be written information. So it's technical written information that will constitute SBIR data. And one more requirement, it must be data that was generated under an SBIR funding agreement. What's a funding agreement? Well, it's any contract or other document that bestows funds on an SBIR firm. Could be a contract, could be a grant. DOE issues cooperative agreements. Those are like grants, but with participation of DOE. Task orders. And I like to think about SBIR data in terms of three terms: what, why, and how information. It's not so-called form, fit, and function information. That term is used to distinguish SBIR data in the policy directive. Think of form, fit, and function data as you just invented the world's strongest swing set that no kid could ever break. It's a special alloy. The compounding equations and radicals for that alloy would be SBIR data. But when the assembly instructions say put tab A and tab B and run a bolt through it and affix a nut at the end, that's form, fit, and function data, and that's not SBIR data. It's not technical. So in this what, why, and how, the what is the research, R&D, technical descriptions of any kind, and other information related to your invention or your innovation. The why is the description of the science behind the technology in technical terms. Just saying this is a laser technology, that's not really the science behind it. But when you start talking about how that laser works, how it was invented, what it does, where it's going to be pointed, all of that is the why. The how is the description of how the innovation was created, how it currently works, how it's going to be applied or is applied, engineering information, manufacturing know-how, all of that is the how, and incorporates some of the aspects of SBIR data. One caution: do not voluntarily disclose your SBIR data to non-government personnel. Many times you might be asked to make a PowerPoint presentation to the government. Mark that carefully with SBIR data markings. We'll talk about that briefly in a minute. And then make sure that if you give that PowerPoint presentation to a group of people, ask the question, are there any non-government personnel in the room? If somebody raises their hand, ask a follow-up question. Have you signed a non-disclosure agreement with the government? There are many types of inside contractors that do sign that type of non-disclosure agreement, even though they're contractors. But if they're just guests of one of the government people and they're sitting there, you're going to compromise your non-disclosure obligation on the government if you disclose your PowerPoint presentation to them. At that point, ask the government to excuse them. So train your staff in how not to talk about your SBIR data to non-governmental people. Who owns SBIR data? The SBIR firm that generates the data owns the data. The government receives a limited license to use it, mostly for evaluation purposes. Think of a license as your driver's license. It allows you to use the public roads. So the government is allowed to use your data, but it can't disclose it. It has a non-disclosure obligation. But here's a kind of a beware. A subcontractor to your SBIR firm under a contract owns the SBIR data that they generate. So if you hire a subcontractor to perform technical work for you, their technical work is going to create SBIR data they own. So that could create a hole in your SBIR data ownership. I caution firms not to hire firms to do their technical data creation, but rather, for instance, to do testing. Now, if you have test results and they're favorable, you want to brag about those. You don't mind if those are disclosed, provided that the underlying data that was tested is not disclosed. But hiring a subcontractor to generate technical data creates a hole in your data. You may have to go around and actually redo that and recreate that data so you own that type of data. So be aware of that. Slide. Let me ask if there's any questions so far. Amanda, I don't see any.
I haven't seen any yet, but if anyone would like to chime in now, you're welcome to.
Okay, I'll keep flying along here then. One confusion about this kind of marking SBIR data is information of proposal is not SBIR data. Oh, I think we have a question, Amanda.
Yeah, so Ed asked, I have one, does an NDA with a subplug the whole?
NDAs to private sector firms are handled differently. Those are handled under a contract with them. So you would enter into a contract with someone that you want to disclose your data to, and I would title that non-disclosure and non-use agreement. So you have them sign a non-disclosure agreement with you in the private sector, but also a prohibition not to use the data you disclose to them, except for some limitations you might put on it. So beware that the things we're talking about here really relate to the government, but if you want to issue a non-disclosure agreement to a private sector firm, that's different. Amanda, was there another question?
Yeah, a couple more actually. Catherine asked if you could repeat what you said about testing. I think she's referring to when you referred to testing versus data.
Sure.
Yeah.
The reason I said that is hiring a firm to help you with the testing doesn't really have them generating SBIR data. It simply tests the data that you developed. I had one firm that I represented that developed a car that could sprout wings and fly. Well, they had a larger firm help them with the flight test, but not with developing the car that could sprout wings and fly. That, by the way, was really important for the Air Force because there are a lot of places in the world where the road stops and it starts again on the other side of a set of mountains. So if they want to transport something, they can just sprout wings on that vehicle and fly over the mountain. But that firm they hired to help them did not create SBIR data. Hope that answers your question. But testing, that's not really the creation of data, and it's not creating a hole in your ownership. Okay, I hope I answered that.
So Mac asked, is data or IP generated after the LOI has been submitted, but before the award? Who owns the IP or data?
Okay. In an LOI, that's a letter of intent. And the letter of intent is considered a non-binding contract. So usually the government doesn't engage in them, but an LOI to a private firm, if you're going to disclose data in that, then you want to have a non-disclosure agreement attached to it. So always be aware that dealing with the government is different than dealing with a private firm. And usually the government doesn't issue an LOI, but it might issue something called a broad agency announcement under which it'll issue task orders. The broad agency announcement, or the BAA, is not a contract because no money is going to flow from it. So be careful not to disclose data in it to the government. But when they issue you the task order to perform work, that will result in data. But normally an LOI is considered something you enter into with a private firm, and that you simply would make sure you have a non-disclosure agreement if you're going to include data in your response to that LOI.
Thanks, David. One more. Considering an STR where the research institution has access to the same data that was partnered, how is that dealt with?
The research institution, let's call it a university, would be a private sector contract, and you would contract with them and protect your data with them. If you're going to then issue a joint proposal to the government, that would be handled the same way. SBIR data rights would commence and start being generated when you get the contract. Beware of universities. They can negotiate with you tough. UACI would never do that, but some universities are very, very eager to grab part of your technology and eventually even patent it if you don't protect your data rights. UACI is not one of those universities, but I'm aware of universities across the country that can be a little bit troublesome to get under contract. I have one client that spent $20,000 to get under contract with a university. That's because their patent office was taking a very hard look and wanted to get their hands on that technology. So when you deal with a university, that's considered a private sector contract, include a non-disclosure agreement in there. When you're dealing with the government, then your SBIR data rights are going to be what protects you from non-disclosure. Okay, shall we continue?
Thanks, David. Yeah.
Information in a proposal is not SBIR data. You do not affix your SBIR legend to a proposal. Now, there's one nuance here, and that is, say in your phase 2 proposal to the government, you reference and include some of your phase 1 SBIR data. That still does not mean that you affix your SBIR legend from Appendix 1 on that document. You protect a proposal with a different legend than your SBIR legend. Other laws protect your proposal contents, so you don't need to worry about the agency disclosing them. The FAR has very strict provisions protecting all proposal contents. The reason a proposal does not get the SBIR legend and you don't mark it is because the data is not generated in that proposal under an SBIR funding agreement until you get into under contract or under a cooperative agreement or a grant. So it's not data generated under an SBIR funding agreement. That fourth bullet there shows you how you can do a legend on a proposal. It's considered a proprietary legend, and you put the data in this proposal is proprietary and may not be disclosed without express consent of, and name your firm, put that on every page, and you'll be okay. But don't affix your SBIR data legend to that proposal. Okay, next slide. Let's talk about SBIR data markings. We talk about marking a document that you're going to submit to the agency, but not the proposal. Go back one slide. Remember, you're not going to put that on a proposal. But if you give the phase 1 report, phase 2 report, an interim report that the agency asked for, PowerPoint presentation, you would want to mark that with SBA's new SBIR STTR legend. You can find that legend in Appendix 1 of the policy directive. And again, a reminder that policy directive is on SBA's website. You can copy it off of there. Go to Appendix 1 and familiarize yourself with the markings. There is also on SBA's website a tutorial of about 15 minutes on markings. And that was given by a person I know full well, me. And you can listen to that if you wish. It's important that you repeat the new SBA SBIR clause exactly, because the policy directive says that inappropriate markings fail to protect SBIR data. Well, guess what? The agencies who want to get their greedy little hands on that data will consider a comma out of place an inappropriate marking. They'll consider a misspelled word an inappropriate marking. So you're better off to just copy that whole clause off of the SBA website and make sure it's there. It consists of 2 parts. One is a 5 term box, and we're going to go into that. And then there's a long paragraph describing the government's rights and obligations. It's a big, long clause. So you want to make sure it's included on your title page exactly the way SBA set it out. Now, you can correct an inappropriate marking or an inexact marking within 6 months. That's the good news. That's called the grace period. The bad news is that the policy directive says explicitly that SBIR data is not protected during that 6-month period. So if you think you were guilty of putting an inexact marking on some document, correct it immediately. Otherwise, the government could give your data during that 6-month period to Lockheed, Northrop Grumman, Raytheon, anybody it wants, and have them continue your technology. So be very aware of the importance of fixing that correctly and exactly. Amanda, do we have a question?
No, Catherine just asked if I could share out the link to the tutorial that you mentioned. So maybe I can connect with you and find that tutorial and I can send it out in an email.
Sure.
Yeah.
Okay. I think that's still up. I don't think SBA got tired of me. Okay.
We'll find it.
Okay, I think Cliff said, yes, please. Let's get our hands on that. Okay, the new clause requires you to fill out a 5-line box. When you repeat the directive, you don't have to include the, boxy outline, but you should include these items: the funding agreement number, colon, and fill in the number, the award date, colon. The award date is on the front page of the whatever contract or cooperative agreement they issued to you. So is the funding agreement number. The SBIR STTR protection period. That protection period starts on the date of award, which is on page 1 of your funding agreement, and then count 20 years out, the birthday of that award date, 20 years out, and include that. So it's one date to another. The SBIR STTR awardee, who's that? That's you. Should be able to get your name of your firm right, and of course the address of your firm. It's not a hard thing to fill those out. It's just important that you do. Next slide. Now, place the legend as it appears in that Appendix 1 in the SBIR STTR policy directive. Put that first on the title page, and then the directive says that legend must appear on every page. Well, you're immediately going to say, wow, that's going to be a foot or a mile high. Well, the agencies and SBA have committed to honoring a shortcut after the title page. And on each subsequent page, you can simply state this page is governed by the SBA, SBIR, STTR legend set forth on the title page as if written out fully herein. And when you include that as a footer on all of the subsequent pages, SBA and all the agencies will honor that as having marked each page. Okay, absent any questions, let's go to the next slide. What are SBIR data rights? There are a bundle of rights that come with SBIR data, but none, in our opinion, none is more important than the government's non-disclosure obligation. The government commits to not disclosing your SBIR data outside of the federal government. And this next bullet is really important. If a federal employee would disclose your SBIR data properly marked to an outside firm or any entity, even a nonprofit outside of the government, they would he or she would subject themselves to felony fines and prison, possibly. That's because the Federal Trade Secrets Act 18 USC section 1905. Here I go. I promised you not to get legal on you, but 18 USC 1905 is the Federal Trade Secrets Act, and SBIR data qualify as trade secrets. That 18 in the USC there, that's the same code, the US criminal code, that provides for the electric chair for shooting a federal marshal. So this stuff is really has teeth. Short story, I once was in a conference room alone with an Army attorney. And after describing to him the non-disclosure obligation, he looked at me and he kind of sneered and he said, "What if I just disclose it?" And I went like this to him. And he said, "What are you doing?" And I said, "I just wanted to see what you'd look like in a jumpsuit." He changed the subject. So that fourth bullet, the non-disclosure obligation has teeth. It really does. The non-disclosure obligation actually underlies the reason why phase 3 contracts can be issued to you without further competition. Because think of it, the agency can't disclose your data outside of the government in, say, a public solicitation. It can't put that data in there. It can issue something called a come one, come all solicitation, which says, please give us your technologies that relate to laser tracking of incoming targets. Okay, fine. You have a laser technology that can track incoming targets. You've worked on that. You've got computer code for it. You've got how to construct the laser. You can bid on that contract, but they didn't include your SBIR data in that solicitation. So you have every right to insist that you get a contract and no further competition. It's called a sole source contract. But the government can't publicly solicit your SBIR data. That's why it has to deal with you as the SBIR firm if the agency wants to advance your technology or apply it in any way. So even the new directive has a requirement that the agency, to the extent practicable, issue the SBIR firm the phase 3. When would it not be practicable to issue the SBIR firm a phase 3? If the SBIR firm went out of business or bankrupted, if the government has no money, then that would be a reason not to issue the phase 3. But absent those types of things, the policy directive, as a matter of law, says that they ought to give a subsequent phase 3 to you, the SBIR firm. Next slide. That unique obligation is really in sharp contrast to non-SBIR funding agreements, and that's why SBIR took off so quickly. When firms like yours used to issue or seek sole source contracts to advance your technology, the government would receive unrestricted rights in computer-related technologies and unlimited rights in any other type of technology that you're going to generate. Well, the government can do anything with under those types of rights. It can disclose the unrestricted data to large firms that might compete with you. It can advance it by itself, can disclose it to the public or any large competitive firm of yours, or do anything with it, even sell it. So that's the difference between the SBIR program, under which they have a non-disclosure obligation, and a funding agreement that, even though it gives you a sole source contract, has unlimited rights or unlimited rights in it. They can do anything they want with the data you develop it. You can't generate a market when the government can disclose your rights on an unlimited or unrestricted basis. So it's the SBIR non-disclosure obligation that helps create the market for the SBIR firm. That unique non-disclosure obligation has helped make the SBIR program what one former vice president called, and because you all got on this, I'll say who his name is. It was Vice President Gore, who called this the most successful program since the GI Bill. And because Congress recently reauthorized it, it's still in business and you can still get contracts under it. Hooray. Amanda, let's take any further questions if there are any.
I don't have any in the chat, but please feel free to take yourself off mute and ask any questions that you might have. While people are thinking through that, I can just give a couple updates just to go over a couple announcements. You should have had a chance over the last couple of weeks to take a look at the FOA, but that full FOA has been listed and is on the SBIR website. So you can take a look at that. And just a reminder that if you're a first-time applicant, you can apply to Phase 0 for support. That may have been closed, and I'm sorry, I should have looked at that by now, but reach out to me if you have questions and I'll make sure I get the correct information for you on that. Again, please feel free to take yourself off mute if you have any questions. And if not, I know that David has offered to provide some support after this. So if you have questions in the coming weeks as you're putting together your final application and submission, you're welcome to share those questions with Sonia or I, and we will make sure we connect you with David. But Mac did have a question. Does this conflict with the Bayh-Dole Act? I probably said that incorrectly.
The Bayh-Dole Act. Yes.
Okay, thank you.
The Bayh-Dole Act is something entirely different from the SBIR program. And no, nothing I said conflicts with Bayh-Dole. That's a conflict of interest related statute, and it does not in any way interfere with the SBIR program.
I have a quick question about subcontractors and NDAs engaged with them. If I'm doing a full application and I have an NDA with a sub I intend to work with, would the sub be eligible?
You cut out just at the end there, Ed. Could you repeat that last part, the last sentence?
Will the sub that I have an NDA be eligible for Dawnbreaker services?
I don't, yeah, go ahead.
And I think I understand your question, and that is, what do you do when you're actually going to have a subcontractor who is going to actually perform technical work for you and develop SBIR technical data themselves under your funding agreement? And remember, I said that could create a hole in your ownership of your SBIR data. To prevent that, in the contract, the subcontract that you enter into with them, you should have a special provision in addition to the non-disclosure agreement, NDA, and in addition to the non-use agreement. You should have a special provision under which they commit to convey ownership of any SBIR data developed by them to your firm. So that's a special provision. Just because the SBIR law bestows ownership on them, you can, as a condition of subcontracting to them, and in exchange for the money you're going to give them, require them to return that ownership to you. And that's a really important part of your subcontract with them. So kind of make a note of it. If you do have to get technical help, make sure that there's a conveyance, a transfer provision, transferring ownership of that data they generate, SBIR data they generate, back to you. I hope that answers your question, Ed.
Yes, yes, it does. Thank you.
Thanks, Ed.
Hey, David, in the DOA document, it says that the government has a royalty-free license to your IP and data. Does that mean that they can go out and, if required, have someone else manufacture or use your IP? I'm a little confused about that.
That worldwide paid up royalty-free license is actually a limited license. The government is under an obligation not to do things with your data, including not disclose it. But it's a broad license for government use inside. And I will say government use inside really relates to evaluation purposes. They can use it to evaluate your contract, evaluate your performance, evaluate whether they want to go forward with you. There are some limited exceptions. They can use it for repair or emergency services and some other things on a limited basis if they need to. But don't be frightened by that word worldwide royalty-free paid up license. It just means the government doesn't owe you anything more, and they can evaluate that anywhere in the world, provided that they don't disclose it outside of the US government.
Thank you.
Thank you, Abraham. Are there any additional questions?
David, this is Ed Weinberg again. I had an additional question.
Sure.
So if I'm applying for, let's say, a phase 1 SBIR, and I win that award, and I'm counting on the data to put me over to apply for a provisional patent. Can I do that under the using phase 1 data?
Amanda, I'm not, he cut
Yeah.
out. I'm not sure I understood the question.
Sorry about that, Ed, but it seems like
yeah,
you
okay,
kind of,
so
yeah.
let me bend over, get real close to the mic, and maybe that'll help. Is that a little better?
Yeah, it just seems sometimes you phase out and
Yeah, probably because I lean back too far away from the mic. So I'll repeat the question. So if I'm considering using phase 1 data to tip off a provisional patent, can I do that while the phase 1 is going on as the small business, or does it have to be initiated or shared with the government?
That's a really technical area, and let me just use the remaining time we have to address that. I always encourage my clients not to patent during the pendency of the federal contract. Wait until after your phase 1 is finished and you've issued the phase 1 report to do your patenting. Any data that you include, first of all, you concede rights to the government in your patent if you patent during the federal contract. So I always encourage my clients, or did encourage them, patent before your phase 1 or after it's done and between the phase 1 and the phase 2. But don't initiate your patent during the pendency of the federal contract, because the government has pretty big rights in your patent and can make use of that patent if you have it issued during the pendency of that contract. With regard to the data, you are going to have to include SBIR data in your patent application. The reason is that the test for a valid patent to issue is, quote, could a person skilled in the art replicate your patented invention? That means you have to disclose so much data that a person who really knows about your area of science and technology could replicate your patent. Well, that's a lot of data. And a patent examiner usually calls your attorney and says, I want more data. I want more data. And so you keep piling it in and piling it in. When that background to the data, to the patent issues, that data is going to be disclosed to the public. You lose the non-disclosure obligation to that data. And the government is scot-free to give it to somebody else because it's now public. And you can't keep something public under a non-disclosure obligation because it's already disclosed. I always encourage clients to consider the SBIR protection when you're considering patenting. Now, in exchange for the patent, you get the patent monopoly. But one client called me and said, what does a patent really cost? I mean, I can afford the filing fees. And I said, the filing fees aren't the real cost of a patent. The real cost of a patent is enforcement. And I said, if you want to enforce a patent, send me a retainer for $1 million and wait 10 years. So that's your trade-off to disclosing your data to the public. A lot of patent attorneys don't know that. They don't know that there's a trade-off. And I would say patent attorneys in this country have me labeled as wanted criminal number one, because I kind of caution against patenting if you're an SBIR firm until you're absolutely sure that you want to give up the non-disclosure rights in that data. So consider it a trade-off. Do that very carefully. There are some reasons for patenting. There's absolutely no doubt that holding that patent is valuable on sale of your firm to a large firm. Why? They're not intimidated by $1 million retainer. They'll pay it. And they'll engage in patent litigation and patent infringement at a drop of a nickel. So the large firms kind of like the patents, but patenting it simply because you think that that's the way you protect it, no, you've got a much more valuable protection with that non-disclosure obligation. It's a trade-off, and make sure you thought about both sides of the equation, not just the thing that the patent attorney is talking to you about. Why? Because patent attorneys want a patent. That's why.
Great.
Thank you, David.
Thank you for that detailed answer, David.
We have a question from McDowell.
Yeah. Let's see. Max said, under copyright law, is my understanding that any person under contract forgoes any ownership of copyrighted information. How does that square with data produced by a subcontractor, which is, I understand, copyrighted material?
Okay. I'm not sure that's exactly correct. With all due respect, let me describe copyright. Copyright is different than patent disclosure rights. First of all, data is not disclosed until your patent is issued. That's on a provisional basis or otherwise. When your patent issues, that's when your data becomes public. Copyright is entirely different. When you write something, when does a copyright accrue to you? If you're using a pen, it accrues to you. Copyright law applies as the ink flows out of the pen, as the typing occurs on your keyboard. As you create a document, that's when copyright attaches to it. So other people can't copy your data if they get their hands on it without getting a copyright permission from you. So copyright law can protect data that you generate, but keep in mind, what you don't disclose can't be copied. So not disclosing it is really the first thing. Copyright is after it is disclosed, and you can put copyright to your firm on the bottom of documents, preferably not proposals, because the government doesn't like that. And the government doesn't like any copyright annotation on documents you submit to it. But in the private sector, you can attach copyright notices, all rights reserved, and your firm name with the year of the copyright and the copyright symbol to any documents you wish to protect that are disclosed to other, say, private firms. Does that answer your question?
He said yes.
Okay.
Great. Thank you, Mac. Thank you. I appreciate everybody's questions. We may have time for just one more if anyone has any additional questions. If not, we can wrap up our session. Thank you again for joining us. I really appreciate everybody being here today. And again, we are really happy to be part of your journey through this process. And I know Sonia and I are ready to help as you're putting together those final applications. So please reach out, and I hope again you'll join us for the commercialization workshops. If you have additional questions for David, you can send those to Sonia and I, and we'll connect you. And Catherine, yes, this recording will be available. It's going to be on the UACI YouTube channel, so you can just look up YouTube UACI, and there's a SBIR playlist there that shows all the sessions that Sonia has done, as well as this one by David. And again, we hope to see you in the next week for commercialization, and we talk to you soon. Thank you, everybody. Thank you, David.
Thank you for the
Wonderful.
kind words.